Hello, everyone, and welcome to Uncivil Law. We've got a whole bunch of law stories today, some of them short, some of them long. We'll talk about some number of them. We'll see how it goes. We probably will cut them up at some later time and release some of them as daily record stories, so this might very well turn into a batch record stream. So I guess on that idea of it being a batch record stream, I'll just go ahead and disable the DVR. That's what we normally do for batch record streams. I can always change my mind later, obviously. Hope everyone's having a great day. The thumbnail, by the way, I hope you guys like it. I paid a artist on Canva on Fiverr to create some stock thumbnails for me, some thumbnail templates. And so they created some thumbnail templates along the style that you saw. So I thought they turned out pretty good as templates. So I'm not sure we'll use them every single time, but it's nice to have a generic template that you can use in a pinch. Like if you're not talking about a particular story where you might use a photograph or something or customize something special, it's nice to be able to have something generic that is specific to the brand that you can just use in a pinch. So we have that, so that's nice. Am I okay? I sound down today? Yeah. Not every day is the greatest, but I'm doing okay. I'm happy to be here with you. I appreciate your thoughtfulness, though, in asking. Let's go ahead and discuss some stories. I'll give it actually one more second for people to join in before I start. I agree. If I was wondering if you're okay, yeah, some days are better than other days. Such is the nature of things. But I appreciate your kind words. Appreciate the hugs. There's nothing especially wrong. It's just that's the nature of depression, right? Or at least it's my experience of depression. I guess other people's experience is different. But for me, it's fairly variable in how much it's impacting me on any given day. And if there's a pattern to it, I haven't figured it out. So some days are good and some days are bad for no particular reason other than, well, it's that day, as far as it seems to be. You look sad. That's a pity. Could be tired. Okay. Well, that's interesting commentary. Thank you. Some say the day blows chunks from the moment you wake up. Yeah. We're not quite we're not even in blow chunks territory. We're just in today's not as great a day as some days. We're nowhere near like as bad as it can be. But yeah. Walnuts? Okay. I haven't tried the walnuts approach to feeling better, but okay. Yeah. Walnuts are apparently health chocolate. Praline walnuts is crack. Praline walnuts does sound nice. Maybe I'll buy some praline walnuts. All right. Thank you, JF. That's very kind of you. All right, let's go ahead and do a story and see what's going on. A U.S. judge has blocked the Air Force from kicking out, and the title at least says, punishing thousands of unvaccinated troops. So some troops have not gotten the COVID vaccine. And the Department of Defense has moved to expel these people from the armed forces. A U.S. judge is stopping this, at least in part, as it relates to religious exemptions specifically. So let's go ahead and read this article. On Thursday, a federal judge in Ohio put a temporary stop to the U.S. Air Force kicking out thousands of service members who remain unvaccinated against COVID-19. Judge McFarland of the Ohio Southern District, a federal judge, granted a temporary restraining order in the case of Hunter Doster versus Hunk Frank Kendall, in which Doster and other service members sued the Air Force Secretary to grant religious exemptions to the service's COVID-19 vaccine mandate. We've covered this at least in part. We covered this specifically with respect to the Navy. I don't believe when we covered it before it was with respect to the Air Force, but it's not particularly surprising that they're different. When we covered it with respect to the Navy had a process for religious exemptions, but the answer was always no. In fact, the process, which was very, very detailed and had multiple different steps, one of them was basically one of the steps was explicitly that the person in the chain of command was supposed to draft a denial, right? It didn't say draft a decision. It didn't say draft a denial and an approval. It just said draft a denial. So part of the process explicitly was draft a denial. So I guess it wasn't surprising every single time the answer was no for religious exemptions for vaccines, right? Even though the law allows for religious exemptions for vaccines, they weren't being granted, at least in the case of the Navy. It seems like maybe the Air Force isn't that far behind. And a federal judge has said, hey, this is a problem. Incidentally, we saw the same thing with the Navy. The issue is federal law, as always. The military is, of course, a creature of Congress. Congress is the one that has the power to raise a military, to raise an army and a navy, and the other forces. They're the ones that have the power to create a military, and they have the power to regulate the military, pass reasonable regulations for the military. So they have the power to create those regulations. They also have the power to create exemptions if they want. And there is a federal law called the Religious Freedom Restoration Act, which basically says that in any federal law, mind you, that anything that impacts religion must be decided by strict scrutiny. This is distinct as it relates to state law, because we've talked about religious neutrality, right? The generalized rule, like for example under Smith, is as long as you're treating religion the same as everything else, it's totally cool. So if you're impacting someone's religious beliefs, but you are not doing it because of religion and you're not impacting their religious beliefs worse than the secular counterpart, under something like Smith, you're totally fine, right? Because there's the religious neutrality. So, but under federal law, by statute, Congress has extended these rights in the federal domain. We're basically like, actually, no, not so much. It's not okay. Because Congress can give more rights than the Constitution requires, right? So the Supreme Court has said the Constitution only requires religious neutrality. Okay. Congress has said actually we'd like to do more than that, which you can do because you want to give more than the Supreme Court requires, which is totally fine. You can do that. So that seems to be at least part of what's going on. The ruling grants class status in a class action lawsuit to the Airmen, Space Force, Air National Guard, Air Force Academy, Air Force Reserve Training Corps cadets who have submitted a religious accommodation request. So all the affected class members, which is basically every member of the Air Force and Space Force in so many different forms, is now being represented by this class, who submitted a religious accommodation request for the vaccine and who were confirmed by the Air Force chaplain as having a sincerely held religious belief and either had their request denied or still pending accommodation. McFarland also granted a TRO, the temporary restraining order, thus preventing the Air Force from enforcing its vaccine mandate, which can entail punishment and involuntary separation from the service against the lawsuit class. Quote, they face separation from the Air Force and other disciplinary measures. A single injunction would provide relief to the entire class, right? Right, a federal judge is telling the military they can't do something because of an operation of a federal statute or federal law. If Congress grants certain rights, then the military can't take those rights away. So, right. Indeed, the main purpose of the lawsuit class is to provide relief through a single injunction or declaratory judgment. Because they have a uniform, maintained policy of overruling religious objections to the vaccine, they've acted on grounds that are consistent to the class. Every member of the class is sufficiently alike. In a class action lawsuit, in order to put people together in a class, their claims have to be sufficiently related. They have to be sufficiently similar because we're trying to adjudicate the entire class. So the only way to do that is if every member of the class is close enough that one ruling can cover them all, among other restrictions when it relates to class actions. But here, like, everyone is in sufficiently the same domain, right? They've all requested religious exemptions, and everyone we're talking about has either had their request denied or delayed. So that's sufficiently similar. Like, we don't really care much beyond that what the facts are because pretty much nothing else is really relevant. They have a religious reason. They've applied for a religious reason. They're being denied. This appears to be in violation of the relevant federal law. So therefore, they're all similarly situated enough to be brought together as a class. Total logical sense. As the Air Force latest vaccination statistics post, 6,800 members were denied religious accommodations, while 2,800 requests remain pending, and only 104 have been approved. This seems like a very low rate. So of the ones that have been processed, which is about 9,000, because we can do math, well, 6,900 if we want to be precise, of the 6,900 that have been processed, only 100 have been granted. So that's a rate of 1 out of 69 where we had an approval. So that's less than 2%. So that's pretty low. In the case of the Navy, it was 0%, so it was even worse. But either way, it seems like maybe these religious accommodations are not being processed according to the relevant law, because Congress has passed the Religious Freedom Restoration Act, and they've passed other acts that are granting religious exemptions to members of the military. They don't necessarily have to, because, again, religious neutrality, so they don't have to grant religious exemptions. If they said, hey, whether you have a religious exemption or not, you have to get the vaccine, right? As long as we're not treating religion worse, we're consistent with Smith. We're consistent with the relevant case law. So we can be like, yeah, we're ignoring your religious exemption because we're just treating you the same as everyone else. But Congress doesn't have to do that, especially when it comes to the military, where Congress gets a lot more control in terms of the regulations that apply than they would in another context. The ability of Congress to regulate the military is more than that would be in relation to the civilian sector because of the nature of what a military is. And also they have independent legal authority for regulating the military instead of the civilian sector. There's special provisions in the Constitution for it. So, there was that. McFarland has ordered the Air Force to provide a response as to why he should not extend the TRO into a preliminary injunction that would apply over the course of the lawsuit. So it's like, well, it's a 15-day restriction, but why shouldn't I extend it as long as the lawsuit is proceeding? And there might be valid reasons. TROs are a disfavored remedy, but they're not unheard of. They're not, I guess rare would be an appropriate description for a TRO outside of domestic violence restraining orders, where they're kind of in their own little domain. But outside of domestic violence restraining orders, TROs, I think you could reasonably characterize as rare, but they're not like unheard of. So, and he wants to convert it into a preliminary injunction. So it's like, well, why shouldn't I do that? Okay, well, let's get some reasons if they are there. Matt Staver, the founder and chairman of the Liberty Council, a religious freedom organization that's supporting the Air Force members, has said, this is a great decision that grants protection for religious freedom from all Air Force personnel under the unlawful COVID shot mandate. The mandate itself is almost certainly not illegal, because the members of the military have to get all kinds of vaccines and all kinds of other things. The mandate itself is not illegal. The problem is the processing of the religious exemptions, which is covered by various aspects of law. So that seems to be the issue. David Schmidt, an attorney for the Liberty Council, told the American Military News that Liberty Council is aware of service members within the lawsuit class who have begun to receive their separation packages, but no service member in the class have hit their separation date, and the judge order will pause those separations. So they might be in the process of being discharged, but they haven't been discharged. So it's not too late to act. Great. They said because there's nothing new and the Department of Defense will put forward the analysis is likely to remain the same. It does seem unlikely that the Air Force would be able to point to anything specific because of the relevant legal interplay. We saw this exact same problem when it related to the Navy and the Navy SEALs, where there were members of the Navy SEALs suing. And it seems like the exact same problem. These are just not being taken seriously, but the law requires them to be taken seriously. And members of the military should understand about having to take orders. And one of those orders is like, you have to take that seriously. Congress gave an order, so, follow it. And generally, if you get a temporary restraining order, it's most often, but not always, converts to a preliminary injunction. I don't know if I'd phrase it quite that strongly, but fair enough. Tilly T has gifted 5 advocate membership to viewers. Well, thank you very much, Tilly T, for gifting some membership to viewers. That's very, very kind of you and very, very appreciated. And I'm sure those people will appreciate it as well. All right, so let's go ahead and wrap this story up. Thus, that brings us to the end of discussion of this article of a U.S. judge blocking the Air Force from kicking members out. It appears that there are various members of the Air Force who have asked for religious exemptions, about 6,900 of them apparently, of which the Air Force is only, of the 6,900 they've actually processed, that actually more than that have asked. But of the 6,900 they've processed, they've only given 100 exemptions. So at a rate of less than 2%. The relevant law does appear to require the United States military to grant these religious exemptions if they are bona fide and won't otherwise substantially harm the service. And it seems like they're just not processing them with the requisite seriousness the law seems to require. We also saw this with respect to the Navy when the Navy SEALs were suing for exactly the same reason. And with respect to the Navy at large, it seemed the Navy was granting 0% of the requests. So the Air Force seems marginally better off because they're almost at 2%. Hey, that's an improvement. But either way, it seems like there's a problem because the military is not enforcing the acts of Congress that Congress passed, which they have to do because they're a creature of Congress. So there's that. So the lawsuits make sense. They will continue to be processed, and at least for a moment, that brings us to the end of discussion of this case. For today's article, we are dealing with a lawsuit that claims that Skittles are unfit for human consumption. This is distressing news. I want to taste the rainbow, but the rainbow may contain poison. Let's learn more. Okay, apparently they think they contain a known toxin that makes them unfit. Okay, a group of consumers are suing candy maker Mars, who makes the Skittles, alleging the Skittles contain a known toxin that make the rainbow candies unfit to eat. How interesting. Okay. A class action lawsuit filed on Thursday in California alleges that Skittles are made unsafe for consumers because they contain heightened levels of titanium dioxide. Okay. Seeking class action status filed in U.S. District Court for the Northern District of California on Thursday. Attorneys say that Skittles were unsafe for consumers because they contained heightened levels, whatever that means, of titanium dioxide, TiO2, as a food additive. Okay. The lawsuit also says that titanium dioxide will be banned in the European Union next month after the food safety regulator there deemed it unsafe because of genotoxicity, or the ability to change DNA. All right, well, first principles first, the United States is in fact a different country and not part of the European Union. This may come as a surprise to some people, but the United States is not in fact a member of the European Union. What might also be surprising to some people is that different countries have different laws, including different food safety standards and what is permissible and not permissible within their food for a variety of reasons, because their policies are different, right? There are different kinds of substances. These substances might have different harm levels or different threat levels, but they might have benefits, and then it just becomes a cost-benefit analysis. Different countries draw these borders in different ways. So the European Union apparently wants to ban titanium dioxide from food. I am thrilled. I also don't care, because the United States is not a member of the European Union. The question is it banned by U.S. law? No. Okay, then I don't know what to tell you except that, it's legal here. If they're in violation of their disclosure requirements and they're using too much, that if they're using so much it's a violation of the law, Food Safety Act or something like that, fine. But because it's banned in other countries does me no good in a lawsuit, right? Mars Incorporated uses titanium dioxide to produce Skittles rainbow artificial colors. Okay. In October 2016, the candy maker shared in a press release its intention to remove titanium dioxide from its products in the coming years, but it's still used in products like Skittles today. Well, that is if they say we're looking to remove it in the coming years, that is a very vague statement. They are not claiming it has been removed. That they are making a very vague forward-looking statement. At some point in the future, we're looking to remove it, whenever that might be. But unless they're lying to you and saying we have removed it, then I don't, no. If they're not being required to remove it by law, then they can remove it or not. And they haven't bound themselves in any kind of timetable. So, okay. According to the lawsuit, titanium dioxide is used in paint, adhesives, plastics, and roofing materials, and can cause DNA, brain, and organ damage, as well as lesions in the livers and kidneys. Well, I would take note that pretty much anything can cause anything in enough of a quantity. Everything is poisonous at some level, basically. And so, yes, it's used in paints. This is apparently not surprising because Skittle apparently uses it as part of its artificial coloring, which is kind of what paint is. So, yes, it's used in paints. I'm sure in different amounts. If you eat paint, you might be consuming way too much titanium dioxide. But there might be a level. I'm not arguing there is. I'm just saying it's possible there's a level that's safe for human consumption. At least the FDA seems to think so. So, okay. A reasonable consumer would expect that Skittles can be safely purchased and consumed as marketed and sold. However, the products are not safe. Unless the products are not unless the products are not marked in accordance with law. So if you want to say they're not properly listing their ingredients on their package, great. If you want to say they're using more titanium dioxide than the Food Safety Act allows for, great. If they're following all the relevant laws, though, then the FDA appears to think they're safe. The FDA could be wrong, but then again, what's safe is a little bit in the eye of the beholder. Because again, everything is sort of toxic at some level. It's like, so it just becomes a question of, well, what is the proper threshold for what we're willing to tolerate? And the FDA says, well, this seems okay to us. So if it's okay with the FDA, then, yeah. So this description is not super promising for this lawsuit. In May 2021, the European Food Safety Authority announced titanium dioxide can no longer be considered safe as a food additive. However, the food additive is still legal in the United States. Once again, the United States is not, in fact, part of the European Union. Okay. According to the FDA's Code of Federal Regulations, there you go. That's what we want, right? What does the law allow for? That's a great place to start. According to the FDA Code of Federal Regulations, that's exactly where you'd want to go look. The color additive titanium dioxide may be safely used for coloring foods generally. Sounds pretty promising if you're the maker of Skittles. However, FDA regulates the quantity of titanium dioxide and may not exceed 1% of the food's weight. Fantastic. You can use it, and it can't exceed 1% of the food's weight. Okay, so your only questions here in your lawsuit is, does it exceed 1%? And are the relevant disclosures relevantly disclosed on the packaging in accordance with law? Which I'm going to assume it is. I'm going to assume all they have to just say is artificial color. And they're there under the FDA law, and they're within the bounds. So this lawsuit is done. Thames of California said he bought Skittles at a quick stop in April and would have not done so had he known. Thames claims that by checking the label would not have helped because the ingredients on the bright red package are hard to read. Are the markings in keeping with the law? The fact that you have trouble reading them and all is super interesting. But the question is, are the markings in conformity to the law? Which I'm sure they are. The case is Thames v. Mars, and Mars did not respond. This case is going absolutely nowhere. Let's wrap this up. So, my friends, we have discovered this lawsuit against the makers of Skittles, who apparently, at least according to this article, are doing everything legally in accordance with the U.S. law. It may not be legal in the European Union, but seeing as we're not in the European Union, nobody cares. It seems that this ingredient is legal in the United States as long as it's not more than 1% of weight. They are not arguing that they weren't disclosed. They're not arguing it's more than 1%. They're just arguing it should be illegal because it's illegal in Europe. No, that's not how that works. Every country is able to make its own determination. The FDA can determine it's a safe product or not, and can make determinations or not under the relevant federal law. If they want to ban it, they almost certainly can, because it's been committed to their discretion to determine what is safe for consumers. And different countries have different laws. So I'm not exactly sure why we are picking on the Skittles, but this lawsuit sounds like it's going nowhere. And at least for the moment, that brings us to the end of discussion of this case. Okay. Yeah. Let's see what else we got. Do I want to do the Johnny Depp thing? Not yet. Do I want to do this thing? Do I want to... Okay, what we got? Let's see. I don't need to do Twitter today. Okay, let's do the Sarah Kavanaugh thing. For today's discussion, we are discussing a recent plea by Sarah Kavanaugh. If that name doesn't sound familiar to you, allow me to give you the story again. Sarah Kavanaugh was a Marine. She served overseas in multiple different tours, and she was injured by a roadside explosive. When she came to the United States, she, like many veterans, had trouble adjusting. And she was able to get assistance and help, not only from the government, but also from interest groups such as the Wounded Warriors Project, who gave her money to help her, facilitate her transition into becoming a civilian and to get help for her medical needs. Also, because of a result of her exposure overseas, she unfortunately had developed cancer. So they were also able to help give her money in response to that so that she could get the medical treatments that she needed to help fight the cancer, get back on her feet, recover from her injuries, and otherwise, integrate better into society. Unfortunately, everything I said was just a lie. So Sarah Kavanaugh didn't do any of those things. Sarah Kavanaugh never served in the Marines. She never served overseas, and she was never injured. And she never had cancer. She claimed she did, and, the Wounded Warrior Project and all the rest was true, but not so much with Sarah Kavanaugh. Sarah Kavanaugh was just a faker. And she was a faker who submitted fakery to the Wounded Warrior Project and others and scammed them out of hundreds of thousands of dollars that was supposed to go to, disabled veterans. But she took it, claiming to have been injured, never having served. Incidentally, she is now pleading guilty to various crimes relating to this because the federal government wanted a piece of her. So let's read the plea deal of Sarah Kavanaugh, who may be serving some prison time relating to the things I just mentioned. All right, so she's going to plead guilty to 4 counts: wire fraud, aggravated identity theft, use of forged military discharge certificates, and fraudulent use of military medals. Oh yeah, I forgot to mention that detail. The use of forged military certificates has a nice little additional bonus to it, because she did work for the Veterans Affairs Administration, which is fine. You don't have to be a member of the military to work for the VA. They have lots of people who are not members of the military who work for the VA. So, she worked for the VA, that's fine. Unfortunately, one of the things she did for the VA was helping to process claim applications by actual veterans. And, she got to see actual claims by actual veterans actually submitted. And so she just took one of these at one point and just, did a little photoshopping and replaced some names, and now it's her certificate. And every time that she was asked to basically validate her story, she knew exactly what to do, because she had seen so many of these legitimate things. She knew what a legitimate thing looked like. She knew what legitimate records looked like. She knew what legitimate claims looked like, because she processed them. So she was able to construct a pretty convincing forgery because she knew what the legitimate ones looked like. So that would be the use of the forged military discharge certificate, where she just took some guy's certificate and just made it hers. Yeah, okay, that's great. Defendant further agrees that between filing the time of the plea and scheduled date is excludable under Speedy Trial Act. So Speedy Trial Act is not a problem. She's waiving that part, which you can do. Defendant will promptly submit to a completed Department of Justice financial statement to the U.S. Attorney in a form to be provided and directed by the U.S. Attorney. Defendant agrees that the financial statement disclosures will be complete, accurate, and truthful. We'd like to know how much money you have so that we can get to some of it. Defendant expressly authorizes the United States Attorney's Office to obtain a credit report in order to evaluate her ability to satisfy any restitution. Great. Defendant agrees funds in the amount of $82,489. Her proceeds from sale of her real estate will be applied towards restitution and other financial obligations. Unfortunately, the amount of money she took is more than $82,000, but I guess it's better than nothing. So we're going to use the sale of her real estate, which was about $83,000, as partial financial restitution to compensate for giving her money that was basically stolen away from the disabled veterans. Defendant has provided this check to the U.S. Attorney's Office. At sentencing, the U.S. Attorney will provide the check to the Clerk of Court for application of any financial obligations. Defendant acknowledges, although the final sum has not yet been determined, it's anticipated the sum will exceed this amount. I would think so, because the amount of money that she's taken is in excess of $82,000. So it's like, this is probably not all we're going to need. We're probably going to need more money, yes. Should, however, it be less, which seems incredibly unlikely, we're going to keep it all anyway as forfeiture. Incidentally, at this point, this is criminal forfeiture, not civil forfeiture, right? Because we're in a criminal case. So whatever problems anyone has about civil asset forfeiture, and there's many reasons to have many problems, this is not that. This is criminal forfeiture. You are giving up the money that you got as part of the fraud, because you can't keep it, in addition to other penalties. So, yeah. So in the unlikely event that it's less than the amount you gave us, we're going to keep it all anyway. That's fine. In exchange for the plea of guilty, here's what the government is promising, and it's not very much, incidentally. The government will recommend the court impose a term of imprisonment at the low end of the guideline sentencing range for the offense level determined by the court. All right, so there is a sentencing guideline which has about 250 different boxes. These boxes are determined by how severe the offenses are, right? So there's how severe what you did now is, and how severe all the things you've done in the past are. How bad have you been in the past, and how bad are you now? These are the box grid, right? It appears she has no criminal history. So she has not done bad things in the past. So she's in history category number 1. So then it just becomes a question of how bad is she now? Where on the table do you fall, right? Once you make that determination, it's going to give you a guideline range of years, right? It's going to be something like, and these are just random numbers just to illustrate the point, it's like something between 84 and 104, just as an idea, right? So the U.S. government, without committing to what the guideline range is, right? So they're not committing to the guideline range. They're just saying that whatever the guideline range winds up being, we'll commit to recommending something on the lower end of the guidelines. but we're not committing to what the guidelines are. So we don't know. We're on the lower end of the range. We're on the lower end of the range. We just don't know what the range is yet, at least in terms of the plea. Or the mandatory minimum term of imprisonment pursuant to statute, whichever term is greater. All right, but not including probation or split sentence, even if permitted. So we are not going to agree to any kind of probation or any kind of split sentencing. This is how far we're willing to go. We will commit to recommending the low end of whatever guidelines range you fall into, which, you know, given the scope of things you've done and the fact that you are being convicted of 4 different offenses at the same time, the guideline ranges might be a little bit higher. So, yeah, but we'll see. It could be a lot of different things. For the purpose of determining the offense level, the government agrees to recommend a 2-level reduction of the offense level for acceptance of responsibility. This is very typical. It's one of the things the government does to encourage you to plead guilty. It's like, we'll give you a little bit lower of a break because you're pleading guilty and saving us the time of having to go to trial, the time, expense, and all the rest of it. It's not much, but it's a little bit. It's a 2-level decrease. It's very, very typical. Okay. At the day of the agreement, defendant has timely notified authorities of an intention to plead guilty. If the offense level is 16 or greater, and they enter a plea pursuant to this agreement, the government will move for sentencing for an additional decrease of 1 level, you know, as an additional break. So, fine. The government is free to recommend any combination of supervised release, fines, and restitution which it deems appropriate. So, while we are committing ourselves to recommending the low end of the guidelines, whatever they wind up being, we have made absolutely no commitments when it comes to auxiliary things, such as what your supervised release will look like, what your fines will look like, what your restitutions look like, right? We're only committing to making recommendations relating to your prison sentence, not this other stuff. Defendant understands the guidelines are not binding on the court, which they're totally not. The court can ignore them. And although the court must consult the guidelines in fashioning any sentence in this case, the guidelines are only advisory, and the court may impose any reasonable sentence in this matter up to the statutory maximum after considering the factors. Yes, so the guidelines are no longer mandatory, and this is a promising thing because they were too constrained. The U.S. Supreme Court changed this quite a few number of years ago at this point. I'm not even sure, like 15 years ago they changed this. It's been a while. But they used to be mandatory, now they're not, which is a good thing, in my opinion. So yes, the court can look at this and say, okay, well, I've done all the factors that determine the guidelines, what the guidelines range are, but they are guidelines, right? This is Pirates of the Caribbean. They're not so much rules as they are guidelines. Exactly so. So the court could go lower than the guidelines. They could go lower than the lowest bound if they want, or they could go higher than the higher bound. The sentencing is in discretion of the court. And so this is just a reminder to them. It's like, hey, by the way, although we are recommending a particular sentence, the court can ignore us. And sometimes they do. And you can't complain because your deal is with us, not with the court. So we'll do our part, but if the court comes and whacks you over the top of the head, that is distinctly not our problem. Right. Okay. Then there's some stipulations as to some aspects of the guidelines. So they say, okay, as to count 1, the total financial loss incurred was more than $250,000, but less than $550,000. This seems correct based on everything we know. So we are stipulating to that aspect of the guidelines. And we're also stipulating that the offense involved 10 or more victims. Those are both enhancements, as you would expect. So we're stipulating to those aspects. But incidentally, we are not stipulating that there are no other aspects that apply. We're stipulating these aspects apply, but as to other aspects, we could say other aspects apply, other guideline range applies, is right. We're not even saying what the guidelines are. We're just saying that whatever they wind up being, we'll give the lower end, but we're definitely agreeing to these enhancement factors. Except as expressly provided, there is no agreement at which the offense level or history applies in this case. Both the United States and defendant reserve the right to argue and present evidence on all matters. So again, there is no agreement from the United States attorney as to what the proper guidelines is. Sometimes you'll see that, right? We will recommend a guideline of this number. Again, that is not necessarily binding on the court because the court might find a different guideline number on top of ignoring the guidelines completely. because the court has to first determine what the guidelines are, which is operation of law, and then determine whether or not to sentence you within that or not, which is basically within the sentencing discretion of the court, and then you're just into an abuse of discretion analysis, which is pretty hard. But here, the United States government is not saying we're committing to any sort of guidelines, we're not committing to any sort of category, we're not agreeing as to the criminal history category, although it's almost certainly one, but we're not agreeing as to the offense level. So we can recommend any offense level we want. Whatever offense level we ultimately get will include a range. Again, whatever that range is, we'll recommend on the lower end of the range, but we're not promising any particular range, right? So it's like, well, so there's a lot here in terms that are uncertain as to the future of this that seem beneficial to the U.S. government. They are leaving themselves open a lot of options. So by pleading, she's not getting very much for the deal, at least in terms of the formal plea. She's not getting very much for it in terms of comparative pleas we've seen. But that's okay. You can agree to any plea you want, and she's agreeing to this one. So then they just remind you what the maximum possible penalties are, because it's like you need to know what the maximum is. These are the limits. Under count 1, 20 years, 3 years of supervised release, and a fine of $250,000 is possible. Under count 2, a mandatory minimum of 2 years, so we know you'll serve at least 2 years, no matter what happens, because it's a mandatory minimum. Consecutive to any other sentence imposed, so it's 2 years plus whatever, plus this is not a maximum, it's a minimum, right? So you will serve at least 2 years. You will serve those 2 years on top of any other sentence, and it might not be 2 years. It's at least 2 years, but it might be more. Probably will be more. We agree to count 3 and count 4 as to those elements, 1 year imprisonment and a fine of $100,000. It's not a very aggressive penalty, but that's what Congress provided for. So be that as it may, right? If imposed consecutively, so this would be the worst possible case, the maximum penalty for all the offenses of pleading guilty are 24 years imprisonment, a fine of $450,000, and a term of supervised release of 3 years. And then also a special assessment of $250 if you care. I'm not sure where these special assessments come from. They seem so de minimis. It's like, who cares? But we'll inform you of it anyway. So theoretically, there's a max of 24 years plus $450,000 in fine in terms of supervised release of 3 years, which the judge could theoretically sentence you to if they find a reason to deviate that hard. There almost certainly is not, but we need to let you know what's possible because sentencing is within discretion of the judge. Defendant agrees that after defendant and defendant counsel sign this plea, counsel will return it along with the money order or certified check we discussed above. Failure to do so, unless the court has made a finding of indigence, will relieve the government of its obligation. So you have to give us the money and a check, and you have to give us the plea in order for us to agree. And then we're going to go through the rights that you're waiving to make sure this is a knowing, intelligent, and voluntary agreement under law, right? So here are the rights you're waiving. You have the right in a prosecution for perjury or making a false statement. The government has the right in a prosecution for perjury or making a false statement to use any statement you give under oath. So in the event we want to charge you in the future for perjury or making a false statement, just to let you know, if you're making any false statements, we got to use those against you in a future proceeding because you're making them, under oath and all. So, there's that. Defendant has the right to plead not guilty or to persist in the plea of not guilty. Defendant has the right to a jury trial. Defendant has the right to be represented by counsel and, if necessary, have court appoint counsel at every stage of the proceeding. Defendant has the right to confront and cross-examine adverse witnesses, be protected from self-incrimination, testify and present evidence, and to compel the attendance of witnesses. Defendant waives those rights if the court accepts the plea. So, these are the rights you have that you're giving up, just to remind you. Defendant recognizes pleading guilty may have consequences with respect to immigration status if they're not a citizen of the United States, which they are, but, we got to inform you anyway, just to be, safe. Okay, and then, just to remind you that, it could impact your immigration status, but it doesn't. The government reserves full right of allocution. including the right to present any information to the court for consideration in fashioning an appropriate statement, the right to make misstatements, misrepresentations, or omissions, or answer any questions by the court. So allocution is the process by which the defendant says what they did that was bad. That's allocution, right? So the court's going to ask you, hey, what bad things did you do? And you're going to say the bad things that you did. That's allocution. But the government also gets to participate in that process, because the government also might have some thoughts as to the bad things that you did. And they might want to offer those thoughts in the allocution if you are less than forthcoming. So they are just reserving their right to also add to the richness of the allocution if required. Except as agreed above, the parties have made no agreement concerning application of the guidelines. Yeah. Defendant understands this is the key. This is a key part of the plea, and basically every plea. This is the key part, or one of the key parts at least, because they're all pretty key, but this is important. Defendant understands the court alone makes all sentencing decisions, including the applicability of the guidelines and the sentence to be imposed. The court is not bound by the parties' stipulations of facts, offense level adjustments, or the government's recommendations. The court is free to impose any sentence it deems appropriate, up to and including the statutory maximum. Defendant also understands that even if the court's guideline determination sentence are different than the defendant expects, defendant is not allowed to withdraw the plea. Right? This is like the sort of big ass thing that people sometimes people forget, and we want to make sure you really understand this, right? Your agreement in a plea, your plea is with the government. That is the executive branch, right? The executive branch is the one that is suing you, which is technically the proper term for this, although you would normally think prosecution, but suing you if you like. Either way works. It's a criminal suit, but still. Anyways, either way, they're the one prosecuting you. They're the one that's the adverse party in this, right? It's the United States of America versus Kavanaugh. So they're the adverse party. So they can make agreements or not, but they can make agreements, right? They are the executive branch. An entirely separate branch of government exists called the judicial branch. The judicial branch is not part of the executive branch. So the executive branch, unsurprisingly, cannot make agreements that are binding on the judicial branch, right? It's like, yeah. So the judicial branch is an independent actor in this. That's kind of the idea. They're literally the independent actor. They're literally the judge. So the executive branch can't bind the judge because that would be dumb. The executive branch can only technically make recommendations. So like, look, here's what we're agreeing to. Here's what we're not agreeing to. And we've read plea deals before in which the government agrees to do more. It's not uncommon that they'll agree to recommend a particular guideline range or a particular sentencing factor, or they'll say, here is the exact number. But still, like, even if they do all those things, which is not atypical, right? Still, the court does not have to accept it. Like, even though we are both agreeing, sentencing is within the discretion of the judicial branch. So once you plead guilty, the executive branch's participation in this is kind of a little bit over, or more tangential, I suppose, because now your ass belongs to the judicial branch, and they might have separate thoughts. These thoughts may or may not conform to your expectations. If these thoughts do not conform to your expectations, too bad, so sad, you already pled guilty. So you can't withdraw your plea. So, you take your chance. You take the chance the judge might just say, you know what? I don't agree with any one of you. That's part of the deal. Defendant hereby waives defendant's right to appeal the conviction and sentences imposed by the court if the sentences imposed are within or below the guideline range determined by the court. But still, what are the guideline ranges? The agreement does not affect the rights of the United States set forth in law, and the government retains the right to appeal any of the court's sentencing determinations. So in the event that the court goes way off the reservation and goes way too low or something, the U.S. government can also appeal. Both sides can appeal the sentence, right? It's hard for either side to appeal, because it's within the discretion of the court, but it has to be within the bounds of reason. It has to be reasonable. And then you're in an abuse of discretion analysis, which is tough. But sometimes it's so low that the Court of Appeals says that's too low. It was an abuse of discretion to go that low. That's happened. And the reverse has also happened, where it's like it's so high, it's an abuse of discretion. But if it's anywhere within sort of a 90% middle range of reasonableness, if reasonableness is on a 0 to 100% scale, if we're in a middle 90%, the court can kind of do anything it wants in that ballpark. There's a lot of discretion to the trial judge. This is incidentally one of the reasons that I make a point of noting that rule number 1 of litigation is don't piss off the judge, because the judge has a lot of latitude. And so they might do a lot of things that could potentially burn you if they're not your friend. So you might not want to try to piss them off. This agreement is binding on the government only if defendant pleads guilty, fulfills all your obligations, does not exchange in conduct that would be obstruction of justice, and doesn't commit anything new offenses. Defendant understands that if the defendant violates this agreement, the government shall be released from its obligation and be free to make any recommendations. If that occurs, defendant shall not have the right to withdraw the guilty plea. So in the event that you obstruct us or commit new crimes, we are completely free of all these obligations, but you're not. Right? It's your breach. It's your breach, not ours. So we get to determine the remedy for the breach. Right? And the remedy is we're free, but you're not. So probably don't want to do that. Yeah. This agreement is limited to the District of Rhode Island and does not bound any other state, federal, or local prosecutive authorities. There probably is no other federal authority that has jurisdiction, although I wouldn't necessarily put it past them. I mean, there might be certain jurisdiction somewhere else in some other federal authority. District of D.C. comes to mind, possibly. But probably not. Probably is limited to Rhode Island. So this might be the end of her federal exposure, although in the event that some other federal district other than the District of Rhode Island has jurisdiction for some other reason, this plea doesn't bind them. So if you've committed some other federal offense in some other jurisdiction, this plea does nothing for you. Also, incidentally, anything you're saying in this plea can and will be used against you in a court of law. But perhaps even more to the point, she absolutely has exposure under relevant state laws, right? She committed a bunch of federal offenses, to be sure, like the wire fraud and the misuse of military medals and the misuse of military forms and so forth and so on. Those are federal interests. But she committed just like fraud against these people, like just normal fraud. And so she committed things that are in violation of possibly several states' law. And this plea absolutely does not bind any of them because they are separate sovereigns. And also, incidentally, your plea deal here and your plea of guilty and anything you say as part of that plea can and will be used against you in any other court of law. So if the various states want a piece of your ass, they get to use all your admissions, including the plea deal itself, which itself is an admission, by the way, including anything you say, including any allocution you say, and this plea does jack all with respect to that. So your criminal exposure in other jurisdictions is going up, and we're doing nothing to stop it. Not that we could anyway, because they're separate sovereigns. We're just letting you know. So yeah. This agreement is the entire agreement. No other agreements exist. No one has promised anything else. This is it. This is all we've promised. And it's not much. Counsel for defense has explained all this. Defendant says they understand all this. Signed. Done. So, yeah. So, Sarah Kavanaugh is going to jail for some period of time. I've seen news. Let me just do it this way. I'll wrap it up by going back to the top. That's better. Okay. So that brings us to the end of Sarah Kavanaugh, quite possibly. Sarah Kavanaugh is going to prison for some period of time. I've seen news articles that say that she's going to jail for 2 years and that the U.S. government is, going on the low end of the range. People are misunderstanding the nature of the plea. It doesn't say that. It says at least 2 years because there's a statutory minimum, and then the court, and they have to tell her that. Like, they have to tell her, like, any minimum and any maximum. They have to tell her the range of what's possible. So it's like, well, one of the things that's possible is one of the things that's required, actually, is that you'll get at least 2 years. You can't get anything more than the maximum, and you can't get anything less than the minimum, which in this case is 2 years. So, like, yeah. So how much term will she get? Well, it's kind of unbounded here, and there's a lot of different offenses, and there's a lot of different things to calculate. So I don't know quite how much time she's going to get by the federal government, but it's definitely going to be more than 2 years. It won't be 24, I'm quite sure, but it's going to be some number of years in federal prison. And if that wasn't enough, her exposure for various state-level offenses is very real. Because, for example, the Wounded Warrior Project, which was defrauded, might have some thoughts that it wants, which could of course be in the form of a civil suit, but they might want to, for example, go off to their friendly district attorney and be like, hey, friendly district attorney, have you considered charging them for fraud? And so there's definitely some possibilities there. So her exposure is increasing. Fake Marine, fake wounded, fake medal wearing, fake Purple Heart woman who went on and just defrauded, like the Wounded Warrior Project and several other organizations, to the tunes of hundreds of thousands of dollars, is going to jail for some period of time and faces additional exposure. And that, for the moment, brings us to the end of discussion of this case. Great. Fun. Yeah, and she's open to civil suits, of course, as I mentioned, and I didn't really mention this part, although it probably is obvious once you think about it. Everything she said in the criminal proceedings can be used against her in any future civil proceeding because they're statements of a party opponent. So in the event that Wounded Warrior Project wants to sue her, well, they have quite a couple admissions of party admissions that they can absolutely use against her in any future civil proceeding. So it kind of makes the lawsuits a little bit easier because it's like, well, how can you prove she did it? Well, she just pled guilty to it, so, that's pretty good proof for us. So, yeah. Let's see. All right. Do I want to do the Roman Polanski thing? I might as well, because, I want to talk about it later. I might as well give the tee up for it later. That'll be good. So let's do that. How do I want to introduce this? I'll just do it this way. For today's story, we are talking about Roman Polanski, long disgraced. No, that's probably the wrong way of phrasing it. For today's story, we are talking about Roman Polanski, a well-known Hollywood movie director, but facing some problems because in 1977 he pled guilty to some various offenses of a prurient nature. Okay. For today's story, we are talking about Hollywood director Roman Polanski. Roman Polanski's woes continue because in 1977, he pled guilty to unlawful prurient interactions with a 13-year-old. Unfortunately, he fled before he could be imprisoned, and he has been a fugitive from justice ever since. Now, there has been a lot of questions regarding his case, obviously, because this has been kind of going on for a long time because he pled guilty in 1977 and never suffered any punishment. So one of the things was like, well, what was happening exactly? But of course, those are criminal proceedings, and a lot of those records have been sealed. But a California appeals court on Wednesday ordered the unsealing of a conditional deposition transcript in the case. So there are some transcripts relating to his criminal case that have been sealed since 1977. And the California Appeal Court has decided that they should be unsealed. So we might be learning more about the horror of Roman Polanski based on these transcripts. The deposition transcript in question is one of Roger Gunson, the former prosecutor in the case who retired in 2002. The Los Angeles District Attorney who formally opposed to unsealing the documents, but lifted his opposition on Tuesday. So the District Attorney didn't want this deposition released, but he's decided to release the complaint. The conditional deposition of Gunson was a post-plea evidentiary hearing designed to uncover alleged abuses, and we agree with the people that there's no factual or legal basis for the conditional deposition to remain sealed. So whatever proper purpose there might have been, assuming there was one at one point, in terms of, you know, internal matters of the prosecuting, in terms of like potential other criminal people, in terms of whatever interests might have existed at one point, they no longer exist, which isn't, you know, terribly surprising since 1977 is quite a few years ago compared to 2022. So, you know, whatever potential crimes or whatever potential internal issues there are, it's a little bit hard to justify keeping those secrets now. The request to unseal was submitted by journalists Sam Wasson and William Rempel, arguing alongside their lawyer that state law and public interest require the testimony to be unsealed. He was ill at the time of testimony and feared it would not be well enough to testify in any case. Well, be that as it may, you know, there's no interest of the prosecuting office or of third parties to keep it secret anymore, so release him. Over the years, this long-suppressed document has contributed to considerable legal confusion and conflicting assumptions about the court's conduct. As journalists and historians, we hope the ruling finally helps clarify the public record. It might do some of that. As of the filming of this video, there has been no date released as to when the records will be released, although we imagine that would happen relatively soon, but who knows, because this has been going on so long. At any rate, we hope the DA's concession, the order the DA will in the future respect the rights of access to the public, rather than require they fight it out. Well, I don't know about that, but at least you're getting this deposition. Director Roman Polanski, pictured in this article, appeared at an international film festival where he promoted his film, which he's still producing films. So he's been a successful Hollywood director. So if you're trying to determine the overall temperament of Hollywood, they are working with someone who pled guilty to prurient interactions with a 13-year-old and apparently have no problems continuing to work with him and give him awards. So that might speak somewhat to Hollywood's overall temperament, but that's perhaps you have an opinion on that issue. This case has been described by the courts as one of the longest running sagas in California criminal justice history. It's been going on for a while. For years, this office has fought the release of information the victims and public have the right to know. It is the belief of several in supporting the unsealing. The transcript would reveal the original presiding judge had violated the law and court standards in abandoning the plea deal with Polanski as a result of media reports and ex-parte conduct. So yeah, there might have been some, there was a whole lot of issues going on, and some of them might have been with the court as well in 1977, in terms of how he was able to escape justice. So there's a lot of problems there. So I don't know if this transcript will reveal everything or even really anything, but at least it's something that might give us something of a clue. And when those records get released, we will absolutely cover them, by the way. Thus, that brings us to the end of the discussion of Roman Polanski's criminal case, an ongoing issue since 1977, in which Roman Polanski, who Hollywood has no problem working with, despite the fact that he pled guilty to pruriently engaging a 13-year-old. And Hollywood has had no problem working with him or giving him awards since 1977. We might gain some information relating to the prosecution in sort of looking at some evidence that the prosecutor themselves generated, which might help reveal the prosecution and or judicial role in how this case went sideways. So we might be getting some information to try to solve the long-running Roman Polanski issue, and at least for the moment, that brings us to the end of discussion of this case. At least now he can't have Skittles. Well, that's not exactly speaking true. Skittles isn't just allowed to use that particular ingredient anymore. I'm sure Skittles will continue to exist in Europe, so. But he won't have the benefit of the color additive magic that is the titanium whatever. So his Skittles will not be as bright. Okay. Kodak Black. Judge orders arrest of Messer County Clerk Tina Peters for violating bond. That could be interesting. Let me save that as a potential story. Stephanie has really been crushing it recently with providing me stories. So everyone say thanks, Stephanie, for helping Kurt by crushing it by providing Kurt stories. Stephanie is providing me stories is a huge help, because I'm, for some reason, like once she provides the stories to me, I'm like, oh yeah, that's a great story to cover. But for whatever reason, I have trouble recognizing it on my own. Not exactly sure why that is, but like if I read it on my own, I'm like, eh. But once she provides it to me, I'm like, oh, that totally makes sense. Maybe it's just like having an outside voice, like be like, hey, this is a good thing, and like, oh, and maybe it's the fact that it's being recommended to me. I don't know what it is, but she does good work. So everyone say thanks, Stephanie. And way to crush it, Stephanie. And Stephanie, you kick ass. We love Stephanie. Let's see. This Southwest story is pretty interesting. I definitely want to cover this. Oh, yeah. Yeah, I was actually reading this lawsuit, by the way, trying to figure out about how to cover that. Did I save this already? Let's see what we got. Most of what she submits is really good. Southwest abortion thing. Tom Forsyth says, all hail Stephanie for tolerating Kurt's condescension. Tom, stop trying to stir up trouble, Tom. Stop trying to stir up trouble, Tom. Okay. Do I care about Kodak Black, the rapper, being arrested? Democrats face health ethics complaint for heated back and forth. house ethics thing. It isn't that interesting. Kodak, is this shut the fuck up? You should just shut the fuck up. Okay, that's maybe a decent reason to cover it. Department of Homeland Security. Do I care? Won't provide info on terror plots until Congress gets waivers from accused non-citizens. Republicans on the House committee want answers about new department's policy that lawmaker says requires them to get privacy release waivers in order for DHS to give them information about threats. That doesn't even make sense. Yeah, I don't know if I want to cover that bullshit right now. Let's see what we got. Let's see. Yellowstone actress charged with workers' compensation insurance fraud. How do you pronounce this girl's name? What? Klitcher? Charged with workers' compensation insurance fraud? I guess that's kind of interesting. I'll cover it if I can pronounce her name. How the hell do you pronounce this? Kuryanka? Is it Kuryanka? Is Kuryanka close? Kuryanka Klitcher? Is that the right pronunciation? Kuryanka Klitcher? That's my guess. Koryanka? Koryanka? That's Koryanka? I guess it could be. Corey Anchor? If it's Corey Anchor, I don't know how we're getting that. Corey Anka, I buy. Corey Anchor? Corey Anka? I'm going with Corey Anka. Last name is Kilcher. Kirinka. Kirinka? Kirinka Kilcher. Kirinka Kilcher. Kionka. I give up. I give up. I give up. Just call her dipshit. Koryanka. Just call her Q. Actress Q. Koryanka. All right, we'll give this a shot. Lord help me. What is Yellowstone, by the way? I don't know. Is that a good... Is it some form... What is that? Is it a good thing? Is Yellowstone a movie? Whatever. I don't care. All right. For today's story, we're discussing the Yellowstone actress, Koryanka Klitschers, who has been charged with workers' compensation insurance fraud. So we have Hollywood people both acting and claiming they're disabled at the same time for the insurance fraud. So let's read a little bit more about this. In a Monday release, the California Department of Insurance said the 32-year-old actress allegedly broke state law by collecting disability benefits while she worked on Yellowstone. According to authorities, Kilcher told a doctor she was too injured to work while filming for her recurring role in season 3 of the hit show she did. Kilcher collected $96,838 in disability benefits from October the 14th, 2019 through September the 9th, 2019. That's a neat trick. Yeah, that's a neat trick. That's how do you, okay. Yeah, she collected $96,838 from October the 14th of 2019 through September the 9th of 2019. So, apparently she's guilty not only of insurance fraud, but time travel. She collected $96,000 in a negative 1 month period. I'm not so sure about this article. I'm thinking this article. Let's move on to other things completely. The story of the time traveling and disability fraud actress. We'll have to wait. Good times. All right. Who knew that the pronunciation of the name would not be the biggest problem? Good times. All right. Let's read this article because this one is an interesting one. I was discussing with Stephanie in some detail earlier, and we might have a live stream on it later with somebody because I'm not 100% sure about whether or not I agree with this one, but I guess we'll get into it as we get there. Yeah. Okay. For today's story, we are talking about a 911 dispatcher who's being charged with manslaughter for not sending an ambulance in response to a 911 call. So this is a pretty interesting just all around because you don't see this kind of thing happening. Excuse me. You don't really see public officials being charged with any crimes relating to their official duties, particularly where the crime in question is not doing something. So here, a 911 operator did not send an ambulance. As a result, we're saying someone died, so we want to charge them with this basis. So this is a weird one, at least in terms of you don't see this every day. So let's discuss what the facts appear to be. A Pennsylvania 911 operator faces a rare charge, of involuntary manslaughter by not doing something, namely by failing to send an ambulance to the rural home of a woman who died of internal bleeding a day later, despite a plea from the woman's daughter that without medical help, she was going to die. Okay. A Greene County detective last week filed charges against Leon Price, 50, in the death of Diane Kronek, 54, based on the reluctance of dispatch to help without getting more assurance they'd actually go to the hospital. I believe she'd actually be alive today if they would have sent an ambulance, said the daughter, 38. Well, I bet you believe that. Because, of course. Price, who's also charged with reckless endangerment, official oppression, and obstruction, questioned repeatedly during the 4-minute call about whether they would actually be taken for treatment. Price was arraigned on June the 29th and released on bail. He did not reply to messages left in his name. Officials say defense lawyer has not contacted the district court. Okay, here's apparently some quotes about this thing. It has to be very clear throughout the entire state that when you call 911, it's not going to be conditioned on someone on the other end of the phone saying if there's going to be a service provider or not. What we're trying to do here is make sure this never happens again. In the 911 recording, an operator identified by police as Price replied to the description of her mother as needing hospital treatment by asking if she was willing to go to the hospital about a half hour away from where she was living in Sycamore. She will be because I'm on my way there, so she's going or she's going to die, we told Price, apparently. Price said she would send an ambulance, but then added, we really need to make sure that she's willing to go. She's going to go, she's going to go, because if not, she's going to die, there's nothing else. She said that Kronk was not thinking clearly and that her mother was her closest relation. When Price asked again if Kronk would in fact go, She responded, okay, well, can we just try? Okay. After they told Price she was 10 minutes from her mother's home, Price asked if they called 911 back once they made sure that she was willing to go in an ambulance. I'm sorry, she said, and Price responded, no, don't be sorry, ma'am. Just call me when you get there, okay? When Tritchnell and her 3 children arrived at the home, she said the person was nude on their front porch and talking incoherently. She got her mother to put on a robe. She just kept saying that she was okay, she's fine. She's the mom, you know, she doesn't listen to her children. She said that she could not call from her home because her mother's landline could not be located and there was not cell service. She also did not call on the way to the home, believing her uncle would soon check on her and have contact with 911. This is unheard of to me. I mean, they send an ambulance for anything, which I think is part of the 911 officer's issues. We'll get there. And here I'm telling this guy my mom's going to die. It's like death, and he doesn't get an ambulance. Yeah, I bet the 911 operators hear a lot of shit, though. Her brother found her the next day morning and died. Okay. Okay, so let's try to parse this out as best we can, because I think this is an interesting case on a lot of different levels, and maybe it'll turn out to be less interesting once things develop. But I think the 911 operator, at least in part, is frustrated because the 911 operator has to deal with a lot of basically very false calls, and has to deal with calls of people claiming things that are a lot worse than they are, simply because they know it will get a 911 dispatch. And 911 has to be careful about its resources. It's triage in some sense, right? It's like, okay, we as 911 are going to dispatch resources based on different levels of immediacy, for example, and seriousness, right? We need to triage our 911 resources because, you know, there's limited resources and we can't send everything everywhere. I know from talking with people that 911 gets a lot of shit calls, and a lot of people call 911 for a lot of reasons that seem decidedly less than emergencies. So it's not hard to believe that the 911 operator is becoming a bit jaded by some of this stuff. And they're saying, oh, she's going to die, and might be thinking to themselves, maybe this isn't a real call. Perhaps because this might not be her first time with this particular person. Maybe it's informed by their interactions with this particular person. So there's a boy who cries wolf problem. And so it's like, well, I'm not going to send the 911 vehicle unless she's willing to go, because she has the ability to refuse service, right? Everyone has the ability to refuse medical care as long as they're conscious. So if you send 911 to me and I'm like, go away, 911 can't touch me, right? Only if I'm not responding, then maybe, but I have the right to refuse medical care. So like, if this person is not going to accept the medical care, then maybe our resources are better spent elsewhere. So it's like, if you're not committing to that, then like, we're wasting our time and our resources. Now, whether or not the 911 operator should be in a position to make that decision or not, right? That's a question that goes to a policy consideration. But at least I can sort of understand why she might be making that decision, even if she shouldn't be empowered to make that decision, right? Why it might make sense from her point of view. So like, her liability under the law is one thing, and I think is really, really interesting because, as we pointed out, this is really, really rare. We want to charge her with manslaughter for something she didn't do, right? And the only way that that works as a legal theory is because she has an affirmative duty. And she signed up to be a 911 operator, so she has some duties by law, but like, does what she's doing make any sense in vis-a-vis those duties or not? I think could be really interesting for the defense. It could also be very, very interesting, especially if she has interactions with this particular person, which again, any 911 operator will tell you that they have frequent flyers that they can set watches by. So like, it might be a very well informed skepticism that this is not what it purports to be. So it's basically boy who cried wolf syndrome taken into criminal law. So it'll be interesting to see how this develops for sure. Let's read some more. The prosecutor said that he's investigating whether there's any policy or training under which they're allowed to refuse services to callers. So if there is any sort of policy, training, or discretion at all in this, then her defense looks a lot better. If there is no discretion or training or whatever. She just made it up out of nowhere. Her case is harder, but not necessarily like, not necessarily impossible. We all deserve equal protection. We all deserve access to medical services. The problem is the resources themselves are limited. So they have to be apportioned out by some level of importance and urgency. I have major concern as the safety and community with this. Yeah, maybe the 911 operator shouldn't be allowed to make those calls. Maybe they literally should not be allowed to make that decision, despite whatever skepticisms and concerns they have. Maybe they should just hit the dispatch, even if it means that, we're dispatching an ambulance who is now no longer available to potentially take care of a more serious thing. So we're going to send an ambulance to take care of fakey McFake cases, even though it might mean that we're no longer available to take care of a child who might need more immediate care because we no longer have the resources. So, sending out these 911 calls is not free in every possible sense, including at the expense of people's lives, because those resources are now no longer available to someone who might now really need them. John Kelly, a lawyer who's general counsel to the National Emergency Number Association, said criminal charges for failing to send help are very rare. Yeah, I would think so. In a case Kelly teaches in dispatcher training, a 911 operator in Detroit received a year of probation and lost a job after authorities said they did not take seriously a boy's call to report his mother had collapsed. The 5-year-old boy testified the dispatcher accused him of playing games and hung up, while dispatcher said that she could not hear the child. On behalf of the mother's estate, they're suing Price and the county in federal court. So this is a 1983 violation. 1983 seems like a bad legal theory. I don't know that we can sue, right? Because it's deprivation of. We're trying to sue under 42 U.S.C. 1983. You guys know how hard that is, right? Like clearly established. You don't have a. I mean, it fails at step one. It fails at step one. You don't have a constitutional. You don't have a constitutional right to medical care. So like her sending, so you're going to try to squeeze this into equal protection. If she discriminated against you because of your race, like I'm not doing it because you're black, or I'm not doing it because you're a woman. If she did it because of a protected class, yeah. If she just did it because you think she's a liar, though, it's not an equal protection violation, because now we're discriminating on reasons that are different than a protected reason. So like trying to squeeze this into a 1983 lawsuit seems borderline impossible, whatever criminal liability there might be under state law. The lawsuit accuses them of callous refusal of public emergency services. Yeah, but as a constitutional matter, you're not entitled to them, right? So it doesn't really work. Marie Jones, a lawyer for the county and 911 supervisors in the federal case, say her clients plan to vigorously defend the lawsuit. I think as the lawsuit, you're there. Like you can't. There's no basis for it. She said there was personal matter ongoing, but declined to elaborate. It's unfortunate the woman died. Certainly, from a personal standpoint, that's very difficult. Yeah, but if you're going to try to sue in federal court under 1983, you're going to have to prove deprivation of constitutional rights that are clearly established from someone not doing a thing that you're not entitled to in the first place as a matter of constitutional law. Trying to squeeze this into equal protection is like, yeah. That's tough unless you can prove she did it because of race, because of gender, because of some sort of protected reason. If she just did it because she didn't believe him, it's not an equal protection violation. So, yeah. The woman had told the 911 dispatcher the mother had been drinking heavily for some weeks before she died and noticed she was losing weight and turning yellow. She said an autopsy concluded that the person who worked in home health care died of internal bleeding. She says she thinks about her late mother every day, about how the former longtime sub manager loved to cook to help people and spoil her 5 grandchildren. She had the biggest heart. If someone didn't have a place to live, she was going to take them to bed, and that was mom. Well, whether or not mom is a good person or not is irrelevant as to the 911 care. I mean, in terms of fundamental principles, right? Like either she has a right or she doesn't. The fact that she's a good person or not is neither here nor there. So, yeah. All right, so let's go ahead and wrap this up. Uh, 1983 does not require a conspiracy, no. 1983 just requires someone deprive someone of fundamental rights. It can just be an individual. Yeah, for 1983, that's fine. So this is an interesting article and something we're going to have to follow because it raises all kinds of... So this is an interesting article and something we're going to have to follow because it raises all kinds of interesting questions about legal duty under state law, the degree to which she had any discretion or judgment, either as a matter of law or training or practice, or whether or not other people have engaged in use of discretion, even if it's not a formal policy, like they know, like that people engage in not doing this occasionally and no one gets reprimanded. So it basically becomes a policy, de facto policy. There's a whole lot of room. There's a whole lot of reasons to go. And like, if she's not doing it recklessly, if she's doing it based on information, perhaps as to this specific person who died, then maybe there's a boy who cried wolf factor. So it's not, you know, it's interesting also because you don't see these cases every day. So there is some sort of issue about why in particular this person is being charged. So yeah, there's a lot of very interesting things here. I don't know how this will end, and I'm not even sure on a policy level how I feel it should end. Right? So whether or not there should be a prosecution here, whether this is a good use of resources in terms of prosecution. So it's a whole interesting case. And as it develops, we'll try to follow it. But that brings us to the end of the discussion for the moment. Moonlight says anyone can have an addiction. Doesn't make them a bad person or mean that they don't have a right to medical support. I'll tell you what I think, Moonlight. I think if it's your third overdose call the day, that you have forfeited your right to live. I'm sorry, but we are not. I'm sorry, but my sympathy. I don't think that, you know, it's if you have overdosed, and we dispatch firefighters and EMTs who come to your house and display and are able to deploy Narcanon, which is a miracle. It's a miracle. And you come back from the dead, and then you do it again, like the same day. I'm sorry, you don't deserve to live. You have made your choices, sir. Our resources as society is limited. You know, how many times should you be entitled to have 911 come to your house? 3 times a day, 10 times a day, 50 times a day? Does it matter? If you're the one inflicting it upon yourself, right? I'm not arguing like 50 different accidents, right, that aren't your fault. Like maybe you're just really accident prone, or like various calamities happen to you because everything piles up. When it rains, it pours, right? That's not what I'm talking about. I'm not talking about it's your 50th call today because 50 different things have happened to you today because apparently the celestial dice hate you, right? That's not what I'm talking about. I'm talking about you have made a deliberate decision to do the thing that we just saved your ass from doing. It would be like you're such a poor swimmer and you're drowning, and we save you from drowning. You're like, geez, I want to get back in the pool. Like, how many times do you really think you're entitled to have 911 come and save you from the pool? That's what we're talking about, right? It's like, how many times in society should we be doing this? So like, I'm sorry. There's only so much I'm willing to do for you. If that makes me cold or heartless, it's just like, maybe our resources would be better spent on helping someone else than saving your ass for the 3rd time that day. Maybe it's your time to go and you don't deserve to live anymore. And maybe by saving you for the 3rd time, we are using resources that at that moment might be better spent somewhere else. So I don't know. That's kind of what my first thought is. Like, I have compassion, but my compassion is not endless. And also I have compassion for the other people. See, it's not even because I'm mad at you because of you. It's not even like you deserve this. It's you are detracting resources that could go to everyone else. You are detracting society's resources as a whole, right? You are, by your actions, taking assets from society. It's like, well, how much does society be willing to give? Right? Maybe we shouldn't send that ambulance because we could use that ambulance somewhere else other than you. Right? Your call to 911 is taking resources that might be better spent somewhere else for your own repeated deliberate action. Like, is there no line anywhere? Is there no, we'll just, you know, thanks for saving me, EMT people. Do you want to sit here while I want to sit here while I go ahead and re-inject myself with the oxycodone, or do you want me to call you once it has its impact? I mean, is there no limit anywhere? I don't know. There's something wrong somewhere on this equation. It's a good thing you're here. It's a good thing you just saved my life, EMT. You know, you should probably not leave, because I'm going to go ahead and just use the drugs right now, and I'm taking too much. And so since you're already here and all, you know, you can save me, and it'll just save us a phone call. It'll be more efficient. It's like, is there no limit? Something about it seems odd. And Joe from the Rag says, you never refuse a 911 call, never? Okay. I mean, that's not a free decision, Joe. If you never refuse a 911 call ever, okay, you're a town that's got 20 ambulances. All right, well, if you never refuse a 911 call, never, if that's your policy, fine. But once you've dispatched all 20 of them, you don't have any more to dispatch. And maybe there's a more important call that comes through. So if your policy is really, we never refuse, ever, then when someone calls and says, oh, I've stubbed my toe, dispatch. I think my muscle's a little sore. I was working out the gym and I think it's a little sore. Dispatch. I mean, if that's your policy, fine. But just remember, oh, my kid is dying. My kid isn't breathing. Well, I don't have any more ambulances to dispatch because I already dispatched it to the guy with the sore muscle and the guy with the stubbed toe. Maybe you want to keep some of your resources in reserve to deal with, actual emergencies. But if you really think you should never refuse a 911 call ever, if you really think 911 should dispatch for every single call, okay, but that decision is not free. That decision means you are going to use resources that are now committed and are now not available if they're needed. I mean, it's a trade-off. It's just a pure trade-off. If that's your policy, fine, but it's a trade-off. Catherine says, why would you send an ambulance for a stubbed toe? Because what he said was, and I'm just interpreting it literally, and he said it in all caps, incidentally, right? I mean, why would I dispatch for a 911? Why would I dispatch the ambulance for a stubbed toe? That's easy. Because what he said is, Joe said, you never, and he used the word never in all caps, you never refuse a 911 call. Never. So why would I dispatch the ambulance for the stubbed toe? Because I never refuse. Never. I have no choice. I have to. Because you said never. And I've interpreted that to mean never. So, I mean, why? Because you gave me no choice. Chauncey said, when a first responder gives Narconon, they have to take the person to the hospital. Well, they might have to, but the person can refuse. If the person's conscious, they can say no. You can't make them go. You can't force the EMT. You can't force the person to go with you. It might be policy that if you give a person Narconon, you take them to the hospital. But if the person is conscious, they can say no. You can't force them to go. If the person's still unconscious, then sure. If the Narconon has not rendered them conscious, then sure. Implied consent, no problem. But if the Narconon has rendered them conscious and they say, I'm not going, you can't make them go. So yeah. Yeah. It's Narcan? Okay, well, either way. It doesn't matter. You guys know what I was talking about. Yeah. And the idea of someone taking a lethal overdose and then overdosing again in relatively short order is not a fantasy. I've read articles about it. It happens with some disturbing frequency. The amount of people who overdose on, say, opiates, and then we use Narcan, and then overdose basically later that same day or the next day is disturbing. It's like, didn't I just fix this problem? So, like, yeah, the idea of these people just using and using and using and reusing and using 911 as sort of this, like, whatever. It's not a fantasy. It happens. It happens a lot. It happens enough. I've read enough articles about it because I read. I read enough articles to be like, yeah, this is a problem. And Melissa's right. Addicts get angry when the EMTs give them Narcan. It kills their buzz. That's often a reaction too. So it's even worse because the Narcan, it is not exactly uncommon after administering Narcan for the person to get angry and violent with the EMT who just saved their life. Even though you were dying from an overdose, well, now that I'm conscious, I'm angry because you killed my high, even though I was going to die. So it's not uncommon for them to be violent. And it's your second time that day or the third time that day. It's like, the whole thing's fucked up. So it's an interesting story. It's an interesting thing. When I got qualified at Narcan, the instructor said, be prepared to save your friend's life and lose the friendship at the same time. That's hilarious. And disturbing. I think that might be enough articles for now. I think it's enough for now. I might do some study or something. Games. You want to play some games? Let's play a game. We have more stories. I just want a break. Try to get some studying today. What the fuck is this? Nate's got to premiere in 14 minutes. Okay. 8 days to go. Thanks for reminding me. That's very helpful. My friend and I will study tomorrow. He said Monday. We'll say tomorrow. What game do we want to play today? You want to play FTL some more? Let's play FTL some more. How much do I have to study? How much do I have to study? The answer to that is just yes. Yeah, the answer to that one is just yes. How much? Yes. More. All the yes, basically. Damn it. I hate it when it does that. Like when you do a Steam game and it loads in the wrong audio and then you have to go back and change it. It's really annoying. No. This game is called FTL, Faster Than Light. It's time for a nap or a drink or something, I don't know. I think I'll make some coffee. That sounds good. Try to get some study in. I'll talk to you guys later.